All right, welcome everybody to our latest episode of Data Discourse, practical advice and insights about digital forensics and eDiscovery. So today, joining me on today's episode for today and the next episode is Bill Saccani. Bill Saccani is an attorney who I actually went to school with at multiple stages of my life, both in law school and high school. Maybe even middle school, correct?
Yes, sir.
Bill and I have known each other for a long time. He is currently president of Precise Discovery, and he handles day-to-day interactions with clients and data on a regular basis when it comes to eDiscovery needs. He regularly interfaces with our forensics team. If you've watched prior episodes, you've already met Jeff Stigler. The two of them work hand in hand in a lot of cases, Jeff working in data collections and different things like that. And once the collection is complete, Bill's job really sort of comes into play where he starts to manage this data and take it from a large volume of data, typically down to a production set and a lot of stages in between. So what we want to talk about in today's episode is really about the nuts and bolts of eDiscovery. Without getting too in the weeds and detailed, what are some things that you need to be thinking about if you have a case that involves eDiscovery? One of the things I will start off with is that pretty much every single case has some type of eDiscovery related to it. The E in eDiscovery just means that it's some type of electronic form of data that is being collected at the front end. So if you think about any situation, you'd be hard-pressed to think of there not being some source of data or information related to a case that doesn't exist in electronic form. Emails, documents, cell phones, social media, all the types of things that we talked about in previous episodes could eventually make its way into the eDiscovery process and arena where Bill handles it and ultimately gets into a point where we can produce documents. So after that long introduction, welcome, Bill.
Hi, Pete. How are you?
Wonderful. So let's jump right into it. Let's talk about the importance of proper collection and identifying data sources early on in a case. How important is that? Where do you see it rear its ugly head when that's not given enough attention early on in a project?
Well, for us, and for the clients is an overabundance of data. If you don't take the time to consider where you're collecting from or custodians, who you're collecting from, we end up with a lot more data and a lot more cost up front to process this data and then finally whittle it down. So, getting that identification up front and before the start of collection is very important to the overall kind of cost to the case and the way that the review is going to go later on.
And timing as well, right? It is more data, more time to get through it, more questions that need to be answered in order to get to a point where we could produce documents.
Correct. So, like you said, the more data there is, more chance for it taking a long time to process, to review, and to get to your relevant set of documents.
And so let's walk through, and I guess the flip side, just to be fair, can also apply here as well, where you can miss data sources.
Correct.
And later on have to go back and realize you under-collected or under-identified, and then you're scrambling to respond to document or discovery requests that you don't have the information for because it got missed somehow in this stage as well.
Correct. So the same goes for that. Undercollection will force you to go back and recollect, which is a cost and a time consideration for inevitably getting documents produced.
And we've done this long enough. We know that what ends up happening there is that there are documents that are missing that should have been collected, and it's a mad scramble at the end to try to get stuff produced before some production deadline or discovery deadline. And you don't want to rush doing this stuff. That's where mistakes are made. That's where things aren't given the proper consideration. So this is an important first step, right?
Correct.
Okay. So let's talk about proper identification of data sources and collection of it. So there are times, I know that sometimes we're involved with that. Sometimes we get involved or you get involved when somebody has just said, here's what I have. I need to deal with this. What do I do next kind of deal. But from your experience in dealing with attorneys, how are they identifying data sources? Like, who needs to be involved in those discussions with them? What participation can we have that might help them uncover or discover where they need to potentially gather information?
I think our involvement, if they engage us early enough, is critical in that we've seen this done over multiple cases, multiple years of doing this, so we can help guide the attorneys to look to appropriate sources where the data needs collected, whether it's just email or email and servers or email servers and some kind of cloud-based system, wherever they're storing data. But we would work in conjunction with the attorneys, and then the other people involved would be, of course, the client and maybe their IT people to help identify where these sources of data exist and the appropriate way to collect each one.
And I think, as you mentioned, after I've done this probably over hundreds, if not thousands of cases at this point, years of doing this, one of the big factors I think that really slows this piece down is that attorneys might not know the right technical questions to ask, especially if there's IT people involved. If a company has their own internal IT resources or they're using an external IT company to manage data or whatever, my experience has been that IT people speak very specifically. They talk in very defined parameters, and if you're not asking them the right questions in the right way or know where to probe based upon an answer, you may not be getting to what you strategically are looking for from a legal standpoint. Does that correspond with what you've seen over the years?
Yes, it does. Speaking of that, recently we've had the opportunity to work with a client who has their own IT resources, and just that communication between, what is needed on the eDiscovery side for the legal standard and what the IT person is used to were two completely different things. So taking that lawyer speak and turning into what the IT guy understands and can give us appropriately for the eDiscovery process is definitely a role that we're like to be involved with.
And I think, and it's something that we do well and that we've honed our skills on over the years, are sitting down with the attorney at the beginning of the case and say, well, what are we trying to accomplish here? What's being requested? What's the relevant facts in the case? Who are the important people? What are their roles? How to sort of lay that out, if it hasn't already been done, to say, okay, well, how do we turn that into an actionable plan that I can tell, Mr. IT, this is what we need to do? Because it's that marrying of a legal strategy with an action plan that has technical components to it that becomes very important. Oftentimes they don't know what all the data sources are. Is there, are they a Gmail email environment? Are they a Office 365 environment? Do they manage emails on premises or in the cloud? Do they use a document management system? Do they just save things on the storage server? Do they save things in the cloud and Google Drive or on individual computers? All those things are important to be able to say, well, here's where we got to go to potentially collect this information, or be aware that these data sources are out there and understand whether you agree or disagree that they should be collected. Just be aware that they're there and that you can make your arguments to the judge or the other side as to whether you should or shouldn't have to go into these data sources. And I think that's become probably even a more prominent role of ours as the years have come on, where we sort of translate that legal strategy into an actionable discovery plan where we can say, all right, this is what we have to go after. We have a good picture of what it is that we're going to potentially need to collect. And that sort of leads into the next question, which is, when is it reasonable to utilize internal resources from a client. So let's say, and there's all different kinds of cases, right? We've dealt with ones where it's individuals, and obviously an individual probably doesn't have an IT resource, so we're dealing with them to sort of talk to them about where they keep data and get a picture of where their footprint is. But what about a company where you're like, all right, we're working with a law firm, we're working with general counsel, whoever it might be, they've got an IT department or an outsourced IT department, and they're saying to us, I want to utilize them. Where is it reasonable to do that, and where does it start to become an issue where you have to be careful about what you're asking them to do?
I think it depends. In eDiscovery, it all depends, but it depends on the tone of the case, I think. So if you think that there's going to be if we're dealing with a case that has a small electronic discovery component to it, and we are, that's kind of the in the background type of thing, I think that's appropriate for an IT department. But if it's a contentious case up front and you know that the sides are going to have these arguments over electronic data, that may be the time to step back and say, do I really want my IT person doing the collection and turning this data over for production if there's a possibility that there's going to be a contested side to the data? Like somebody's going to say, well, this wasn't collected properly, this was manipulated. Do you really want your IT people on the stand if it comes down to that? At that point, it may be better to have an independent forensics person go ahead and do the collection. It just saves you a lot of hassle at the end.
Well, and I think that becomes the critical question. Look at that IT person and say, do I want them on the stand? Most of the times the answer is no. And it doesn't mean that they can't be involved. I think we've sort of taken a hybrid approach oftentimes on things where it's like, look, let us come in and tell you where we think you need to collect the data, from what data sources it needs to be pulled in, what filtering is reasonable to do on the front end. Then they can push the button, saving some hours on our end, but they're doing it our direction. And then if there ever is a question about why something was done a certain way or not, it's really us answering to say, well, we did it because this was a reasonable approach to the discovery, the way that it was requested and the way the data was set up. So I think that hybrid approach as well can also have be a nice way to sort of bridge the gap to say, utilize some internal resources, but make sure they're doing it under our direction. So if there's ever a question about the reasonableness of how these things were collected originally, that becomes less of an issue. We're also seeing, I believe, and I'd like to get your perspective on this, that the data sources have certainly changed over time. I can't think of very many cases in the last couple of years that haven't involved at least one phone, some mobile device. I mean, occasionally you'll get just email collections and things like that, but clearly phones have become an important part of most cases anymore. But there's even more. Microsoft Teams. A lot of organizations adopted Teams as their internal meeting platform and all the rest of it. And it's an alternative to Zoom that people might be familiar with in the sense that it allows you to have web meetings. But Teams also is more than that. It allows you to have internal chat and discussions, and people can use it as a less formal way of discussing things with each other. So rather than an email chain, you may have people that have chat messages in groups or whatnot within the Teams app. Are you seeing more of that? And do you see that might continue to expand in the future, that something like that may be a more desirable target for somebody seeking discovery because it's going to be a less formal way of discussing things and communicating, that they're going to want to see what people are talking about?
Yeah, I could definitely see it growing and being used that way. Personally, I haven't seen too much of the Teams. I don't know whether Zoom has such a, kind of that market share right now that I haven't seen as much of the Teams aspect of, the Microsoft suites that comes through. The rest of Microsoft, of course, is pretty prominent, but, that one is one that I think will grow and, people, like you said, feel less formal when communicating through that. So that's going to be definitely a good place for people to look for relevant data on any particular case.
Yeah, and like text messages where they want to say, hey, I want the more spontaneous sort of communication that's come through Teams. And again, there's other platforms that are similar to it, whether it's Slack or I forget some of the names of some of the other ones that people utilize in this way. They may become more targeted sources of information. And it kind of goes back to what we've been talking about, which is identifying your data sources. You don't want to find out later on, well, heck, this team used Teams regularly to communicate about the issues at hand, every day, all day long. This was their primary communication methodology, and somebody just didn't think to ask about it and see if it existed out there. So, that kind of goes back to the point, I guess, about making sure that the proper data sources are identified at the beginning. And as we've discussed in other episodes, and I know you're very aware, this is an ever-changing target. I'm sure you've seen that data sources have morphed over time. You used to be that you could count on a server with server directories that you could go in and pull out data, and you see a lot less of that anymore. I mean, it's morphed over into more cloud-based storage, and things just kept on people's individual computers, probably even in a less structured format, and means that collecting it and searching it becomes even more critical. Does that align with what you've seen over the years?
Yes, and it has morphed that way over years, but it also goes back to now you have duplicate data sources and things like that, because some people will save it to their computer because they want to work with it offline, but now it's also stored up on the cloud. It just is ever changing, and it's always going to be a moving target, and it morphed over the years of eDiscovery, and I think it morphs over the course and life cycle of a case as well. Like you learn and identify different sources as the case moves forward. I don't think it's not set in stone that these are the only sources of data that we have to grab at the onset of the case, and we're kind of stuck with what we decide.
Well, and I think too, with the pandemic, with more people working remotely, it also shifted data sources to be more online. Or more localized in some instances where, people are not coming into the office every day from 9 to 5 and connecting to a server and saving data and to find locations. They may do a similar process to something that's stored online, or they may be doing it locally and working off their individual computers. And that certainly, I think, has changed a bit about where we consider data sources, particularly dependent upon how an organization is structured.
Yes.
Can we talk for a minute timing, the importance of collecting quickly? Why is that potentially important?
Well, I mean, this is more back towards the IT side of things, but one, data can get changed, data can get overwritten. Like if you're not paying attention, there's so many different things that can happen in a time span. Like, so as soon as that that's a data source that you want to collect, you have to move quickly just to make sure no corruption of that data takes place, and get that captured as it is for your litigation or your case.
Well, and collecting can be the same step as preserving, but doesn't have to be. Preservation can take a different format. That doesn't mean it needs to be collected. I can think of instances where, maybe it's early on and clients saying, look, we're anticipating a lawsuit or something's been filed, but we don't know where it's going to go yet. We're not ready to full bore go into discovery at this point. There are steps you can take to preserve data, so you're not fighting a spoliation argument somewhere along the way, that don't necessarily require us coming in and collecting it at that stage. Maybe you're not ready for discovery yet. I can think of a couple instances where, for instance, in Office 365, which is a pretty common platform that people use Microsoft Outlook as their email, you have the ability in most of those versions to go in and to put a lit hold on emails or people's custodians' email boxes or emails from a certain period of time. And with a lit hold, what's your understanding of what that does to an email when that is placed upon it?
Well, that's basically just making sure that anybody in your organization cannot delete that email, or I'm not sure if it goes over to OneDrive or not, anything within that Microsoft suite, but it stops the ability to delete this data without authorization from the IT or your legal team, so that you can't have a spoliation issue later on that, hey, John Smith deleted all of his inbox and there was email in there that was needed.
And depending on the settings and depending on the platform you're using, my understanding with some of these lit holds are it really doesn't affect the end users. They can still move something off of their email box, for instance, and hit delete, what looks like delete, to get it off their server to allow them to go about their normal business. But the lit hold is preserving it on the server level, so that it's basically a marrying of the two, where it's like, look, we know this stuff's potentially important. We have to save it back here in the background. So even though they say delete, it's not deleting it. It's just removing it from their view. And it can apply across Teams accounts. It can apply across the OneDrive, like you mentioned, different things like that. So that's one example of a lit hold using a platform that people regularly have. Preservation may be as simple as saying, look, we got a laptop from a former employee. We think we might get sued or whatever. Lock it up and put it in a drawer. Don't touch it. Don't recycle it. Don't turn it on. Just leave it in a drawer. That's preservation. And that may be perfectly reasonable to say, we took these steps to make sure this data, didn't go away. So preservation has a little bit of a different meaning of collection at that point. But if you do know, to your point, that, hey, this data is important, we're going to have to move it into discovery. Sitting on this is not a good idea, because we've seen it. People will delete stuff, not nefariously. Sometimes it's nefariously, but usually not. Hard drive crashes, whatever it might be. And you got to go explain to a judge somewhere along the way that, hey, I know I should have preserved this stuff. I should have taken some steps to make sure nothing happened to this, but I didn't. Oops. And that doesn't always fly. And who wants to spend a bunch of money arguing a spoliation argument if you can take these simple steps? So I think that collection, the analyzing, the preserving, the discussions with IT is a very important part of the whole process. It's something we regularly get involved with. It allows you and Jeff to have the tech speak about what it is we're dealing with. And it also starts to form the basis for, hey, here's what we potentially might have to deal with in terms of volumes and data sources and things like that, which everybody wants to know as quickly as possible. And we'll get to that. What's this going to cost me? How much stuff am I going to have to get through? So all these things are important. Another step that's more and more often, certainly in a federal jurisdiction, and we're seeing it creep up a lot more regularly in state jurisdictions, is the meet and confer. And in the meet and confer, this is essentially what it sounds like if people haven't done this before, which is a judge is asking you to meet with your opposing counsel to discuss discovery issues, including eDiscovery, and see if you can come to an agreement about how you want to handle certain things. And this is an area that can really take away some uncertainty in how to approach things and how you're going to formulate a consistent and reasonable eDiscovery plan. I'd also point out that a meet and confer and any agreement that comes out of there doesn't have to be the finalized agreement. It can be an iterative process that says, all right, we agree to take these steps now, find out what we're dealing with, and come back and discuss it later, and then work your way through it. And I think throughout the eDiscovery process, taking an iterative approach is important. I'd like to get your thoughts on that, an iterative approach, both from eDiscovery in general and as you're bringing things to the meet and confer. Why is that something that becomes important?
It goes back to, as we discussed, it's a moving target. You don't know you don't know volumes, you don't know what you have until you start getting in there and looking. You don't know, you may find something that points you in a different direction. Like, oh, wait, this person was using an external drive they were saving all their documents to. You didn't know that. You might not necessarily have known that right off the bat, but it's something you found out later, going through the data. So I don't think there's any one case or, eDiscovery in general that you can just say everything's going to fit into this one box. So, to not say that it's iterative and you're going to move along and progress and change things as you move forward is kind of foolhardy.
Yeah, and I think to your point, you don't know until you know. And you find things out by actually spending a little bit of time and effort to examine, to calculate some volumes, to look at some different things. And, you can be preserving in that same step or collecting in that same step and having real information in front of you and rather than just guesses. I mean, I can't think of how many times we've had somebody come to us and say, well, how much is it going to cost us to do eDiscovery for, 10 people? And that's like us saying to them, well, tell me how much this lawsuit's going to cost me. Well, the lawyer would turn back to me and say, well, what's the case? Which side are you on? All right, well, what's it involve? All right, well, how many people are potentially relevant witnesses? How many, they're on and on and on. You would have to ask questions, a lot of questions to have answered in order to say, well, based upon what you're telling me, here's what I think a lawsuit like this would entail effort-wise and therefore cost. It's the same thing with eDiscovery that, we have to get some basic information. Otherwise, we can give you an educated guess, but it's just that. It's a guess until we know. And a lot of times and I know you've heard this, is people will say, well, just assume 10 gigabytes of email per person, there's 10 people and, and we'll say, all right, we'll forewarn them. We'll say, but just so you know, it could be something drastically different. It could be half as much. It could be 10 times as much. We don't know. We're just guessing at this point. But they always seem to forget that and say, well, you told me this was going to be X, Y, and Z, and say, we were estimating in the dark at that point. You really need to take these steps if you want any clarity. Has that been your experience and how people have come to us with inquiries about eDiscovery?
Oh, yes. I mean, every attorney, and rightfully so, they want to know the cost for their client up front. It's just a moving target, and you cannot, just by getting on a phone call one time with the attorney, there's no way to guess volumes. And doing this over the years, it's come down. It's how long, what's the time frame, what's the date filtering, what type of business is your client in? I mean, that's there's some that will be a year of data for a person, or a year of email for a person, maybe 3 gigs. That it seems to be a reasonable. But if it's a architectural firm where they're emailing CAD drawings or a lot of attachments back and forth, that same time frame could be 30 gigs. You just don't know until you get in there and see what the data is showing you.
And a lot of this, it goes back to this meet and confer that we started talking about. That's the kind of things that the judge is going to ask you to discuss with the other side, and to try to get some clarity around it. And so, understanding specifics and not guessing, understanding volumes and not guessing, are all sort of the prelude to having meaningful meet and confer discussions, setting budgetary expectations, understanding, what type of time frame and legal resources you're going to need to get through all this stuff. So it's something you should be encouraging the client or doing as early as possible so you have some clarity on this. Now, in these meet and confers, and the way our involvement, I think, has typically been with these, are more so in developing what might become what's called an eDiscovery protocol. Let's talk about that for a second, because I want to discuss what an eDiscovery protocol is, how these come to be, and what we typically see in eDiscovery protocols when we're approached with them. Can you talk a little bit, first of all, about what is an eDiscovery protocol?
eDiscovery protocol is going to be your roadmap for, one, how you're going to receive data from the other side,
or produce it to them.
Yes, that's the flip side is, whatever you're agreeing to, that's the way you want the data, that's the way you have to produce the data. So it's how you're going to exchange the information between the two parties. And there's a set, standard of, you can expect that it's going to be X, Y, and Z. And, there's no surprises. This is what you agreed to. This is how we're going to produce this data. And moving forward, it always goes by the protocol.
And the protocol can have what you just described, which is the format of production, right? So it's like, maybe they want PDF files. Maybe they want load files to put them in their own database program to utilize. Maybe they want printed copy. It can be whatever the parties agree to. But typically what we see is there's agreed upon set of fairly standard metadata fields that are exchanged. It's information about these files that can be typically important about them. And we'll get into what some of these metadata fields are here, but it can also be how you're going to search this data. And that can be very helpful because it takes a lot of the uncertainty out of, all right, what am I supposed to do with all this to meet my obligations of discovery and then also at the other side. So search terms are still a fairly typical strategy that are used in a lot of cases, partially because attorneys understand them. They understand basically how they work. They're more comfortable with them. It's imperfect, certainly, but most parties are okay with dealing with the imperfections that come along with search terms. eDiscovery is never 100% perfect, but it allows them to move this forward in a way that everybody tends to understand. We've seen this. I've seen this. I know you have, that you can't go into something and say, well, I'm going to apply this set of search terms and is what it is. And there is no discussion on it past that. This is how we're going to do it. That's not a reasonable approach to this. Going back to the discussion or the conversation around an iterative process, how important is it to have an iterative process for searching that you do, and why is that?
Well, I mean, recently we had a chance to work with a client that, we got the search terms and we could tell right away, just by doing this for a number of years, that these were going to be kind of overly broad, so to speak. So, we processed the data, got it ready to search, ran the search terms, and we probably hit on 95% of the data. So those search terms did not narrow it down in any significant way. So now you have to go back and look at these search terms and say, why is it hitting on so many documents? Is there a way for us to narrow this down? And that's where the iterative process comes in, because now we can go back and look and say, search term A is the main offender of hitting all this data. So why is that? Let's take a look and let's talk with the attorneys, get that squared away and see if we can either remove the search term completely or apply some kind of narrowing, connector or anything like that to help narrow this broader term down to something that's more reasonable to produce relevant data.
Well, and a couple examples of that come to mind. It's like, we know in looking at some search terms, we could say, this is going to cause a problem because it's just way too broad. You would never run the word the, right?
Right.
Every other document, if not every document, is going to get a hit on the word the. So we don't need to understand a case. We don't need to understand, the issues to say the is probably going to return a lot of false positives. So we know from experience looking at cases when a word is too generic, is too common to potentially be a reasonable search term on its own. And we can then suggest to them, well, maybe we need to use the in relation to other words, or make it a phrase like it has to be the whatever, in quotes, and it has to have these two next to each other. It has to be the within so many words of another word. There's lots of ways to Boolean search this stuff is what it's called, to expand it out. But you don't know whether it's completely unreasonable until you've done one of these hit reports and you can show. Now you're looking at numbers and you're saying,
Right.
look, this one search term is returning 95% of the documents in the case. That alone should tell us it's not a reasonable term. We're dealing with a case right now where that's the case because one of the search terms proposed is the name of the company. It's in every email footer. So anytime, Bill would write an email and say, Bill Saccani, precise, if precise was one of our words, it's going to get a hit. Doesn't matter what the content of the email is. So you can look at that and say, logically, we don't even have to sample this stuff. We know that this is a bad search term because of that. But sometimes it can be an unusual one where you're like, boy, we thought this term was specific enough, but now looking at the number of hits, it's not. Why is that? You can sample through the data and find where your false positive hits are. That gives you some guidance for how to narrow these in. But to your point earlier, and particularly on this meet and confer, as it relates to search strategies and narrowing this stuff down, you can't do this in all one fell swoop. You got to look at results, make adjustments, be willing to argue those adjustments, try to get agreement on the other side as to why you're adjusting it. And most of the time, I've seen they agree too because they don't want to get tons and tons of garbage. And so you try to work this out. And if you can't, you get the court involved, or you say, look, we're going to go this route and we believe it's reasonable. And if you need to bring this up with the court and argue that it's not, that's up to you. That's that iterative process that lets you get to a point where you say, we have a defined search strategy that's documented. We showed how this, how the decisions were made, why it was made, and it was based off of real numbers, not us guessing when nobody knows until you get to that point. I think that's very important.
Yes, I think that is important, and it helps the client or the attorneys a lot more than just generically speaking about, we think this is a good search term. We think this is a good plan. If you have the numbers in front of you, there's no disputing that, hey, this is unreasonable and needs to be adjusted.
Right. And reasonableness, like in any case, is very subjective. Maybe the other side's going to say the word "the" is a reasonable search term because your company's called "the." Okay, they can make that argument. You can make your argument. You have to try to find some middle ground where possible. But the point being in all this, that thinking this stuff through, deal with real data, real numbers, starts to become very important in the capabilities of putting together a reasonable eDiscovery strategy. So we talked about the importance of collection, the importance about getting to a point where we have real information that we're discussing, real volumes and data sources and things like that. And we touched base a minute ago on a format of production and metadata. What is metadata, number one? And number two is, why is it important?
Metadata is going to be all the information about your file as it existed whenever it was collected. And hopefully, if it was collected soundly, all that metadata stays intact. And we can discuss that later, why it's important to collect appropriately versus just, and we've had clients do this. I'm just going to copy this file and I'm going to send it to the eDiscovery vendor via email and just have them throw it into the case. Now, that kind of messes up the metadata because now you've transferred that file multiple times without any consideration for keeping that intact. But metadata is going to be all of your information on that file the way that it was when it was created and collected. So it's going to have your date created, date modified, author, file title, all that type of information, so that you can use that to help you narrow down specific files, and it goes to search strategy as well. Sometimes if you want to file type and particular dates and things like that. So the metadata is important because that is just another tool for the attorneys to go and sift through their data and help narrow down to relevant data. So if, for example, your search strategy said, we're going to use these key terms and we're going to say, the relevant time period is January 1st to November 1st. If that date is not accurate, then now you have an issue because it could either fall outside of your date range or inside your date range. But it is just a tool to narrow those down.
So it gives additional levels of searchability that most people have come to expect at this point.
Yes.
And you mentioned, some of the metadata fields you mentioned, most of those I would think are related to what we'll call eDocs, standalone non-emails. What are some metadata fields or common metadata fields for emails?
Oh, well, same. You're going to have your dates, but it's going to be date sent, date received, who was the author of the email, who sent the email, who the email was to, who was CC'd, it even goes as far as capturing the BCC, the blind copy as well. So, you can use that to help narrow in on time frames.
And the email subject,
yes.
Which is another poor one. And I always use the example like on a PDF file, for instance. If you accepted or the other side accepted a hard copy of that file or a metadata scrubbed version of that file, they might read a file and say, all right, I can read the content on here, but maybe they didn't know that the title of the file was, how we're going to put our competitor out of business in 2023. And that might be important information. And if it's not handled properly and exchanged properly, that's a piece of evidence of that file that should have been exchanged in discovery, may be very important and critical to some documents. And so managing the metadata is important. I also want to, while we're talking about metadata, talk about the importance as it relates to emails and how family relationships are maintained with emails. Can you explain what a family relationship is with emails and the importance of that?
Sure. The email itself is, well, let me step back. So a family relationship is just going to be that those documents are tied together. Usually it's going to be, the email is going to be a parent of the family. So that is the main document that exists. All the attachments within that email, those are considered children. So those are going to be a sub of the parent email, so that once you see this in a metadata, or once you see this in a database versus, let's say, once it's in a database, then we're going to see that relationship that, hey, this is, email A is the parent, and PDF B, PDF C are the children of that email. So that relationship is kept within the system so that the attorneys know, hey, this goes along with this family group.
And for instance, if an email said exclamation point, exclamation point, exclamation point, read immediately in the email subject line, and all it says in the body is see attached, you're probably going to want to see what was attached to that email. And so maintaining that relationship between the email and its attachments in that simple example becomes very important. And that's what email families in a very simple way allow you to do.
Correct.
And there's also something called threading on emails where, an email gets replied to or gets forwarded or reply to reply to reply, where it's a chain of communications that, you have lots of emails that may have come into it. And for ease of review, sometimes people want to see threaded emails together, even though they may be separate documents, to kind of look at those together and say, look, I know all these emails are dealing with this one subject. So if I read the great-great-great-grandparent of all of these emails that contains all these others in it, I don't need to look at the rest because I've already consumed them within this email threading. And that's another thing that email metadata allows you to do. Is that correct?
Correct.
So we talked about the importance of metadata. Another metadata field that we collect, if the collection's done properly, and that we extract when we process data, is something called a hash value. Can you explain for a second what a hash value, MD5 or SHA hash value, the two typical ones you see? first of all, what's that look like? What is it, and what's the importance of it?
Sure. I mean, in the generic term, it is a long string of numbers, and it is unique to each file. There are different ways that processing engines go ahead and produce their hash value. It's usually based off of all the document metadata, the file name, file size, date, things like that. And I know there's some programs that will allow you to apply document sender and to CC those fields as well, so that if it's truly that is all the same, then those two hash values are going to line up. So it's basically it's going to be somewhere north of 15 characters. It's a big long string of numbers and letters. But what that allows the system to do is deduplicate the data. So if document A has a hash value that is equal to document C, then it knows the system knows that those are two identical documents, and it can set a duplicate aside so that the attorneys don't have to look at multiple copies of the same document.
So, for instance, an email goes out in the organization and 10 people are CC'd on it, and it says, hey, we're meeting in the conference room today at 10 a.m. for an important meeting. It's the same email to 10 people. 9 of them could get identified as duplicates to say, look, we don't need to produce this 10 times. We can produce it once. All the information's within it. One of the things I think we've learned over the years is sometimes people want to know, well, who else had it? Well, you can see the recipients on there, but we can also flag it and say, this also came out of these other people's mailboxes. But that's the only difference. Getting it from over here versus from over here would show you that saves you a lot of volume in terms of documents you may be processing or producing or reviewing.
Yes.
It's a good automated, reasonable process. It's been accepted as an eDiscovery sort of standard thing at this point that allows you to get rid of a lot of volume without having to look at each individual record.
Correct.
So that proper use of deduplication and metadata collection and all the rest of this allows you to do things like that. So one of the things I always, we're talking about, all right, we take the data, we process the data, we extract the metadata, we also extract the text out of files, right?
Correct.
Okay, and what's the importance of pulling the text out of individual files?
Well, that allows you to search the data, search the documents. So, you can kind of think of it as, now, you can open up a Word document and you can search that Word document for your keyword and you can pull it up, and that's perfectly fine. What the review systems allow you to do is it extracts those text that text out into its own individual text files. So now that's embedded into the system. So now when you run your keyword search, it's not against one document, it's against all 100,000 documents in your database, and it's going to pull back, instead of 100,000, it's going to pull back 10. These 10 documents have this keyword. So it just allows you to search more robustly within your data set so that you can do these searches at one time across everything, as opposed to trying to open up individual. Well, I think this document has this word in it. I'm not sure, but I'm going to open it up and I'm going to search it. You don't have to do that now. You can just go into your review system and type your keyword searching in across the extracted text.
So how does the system like that handle documents that are a scanned image or a PDF that may not be searchable on its own?
Sure. So as we process this data, we identify documents. Of course, you're going to want to use the extracted text. The extracted text is exactly the way the text exists. So, if it's a Word file, you're going to get extracted text. It's going to pull the exact verbiage out of your document and create the text file that way, which is, almost 100% accurate. Now, OCR, what that allows you to do, it is optical character recognition, and I'm sure a lot of people know what that is now. It's so commonly used today when you're dealing with these cases. So what that does is it's a system that will go through and read your document, or go through and look at your document and pull out, and it will actually create the text file based on what it's seeing. So the text that maybe a scanned image is going to now be converted to a text file so that you can search that data as well. Now, one thing with that is it's not 100% accurate, and it depends on how clean your scanned version is and what system you're using to OCR.
So it's an interpretation, not a copy paste.
Correct.
And so you have to be aware that when you're utilizing OCR to do text searches, it's just inherently not going to be 100%. It's better than nothing, but it's not 100%.
Right. There's a lot of times where an L will be an exclamation point, things like that. So it's just a tool to use to help make that document searchable. It's not 100% reliable, like, hey, if I run this search term and it doesn't show up, that it doesn't exist, but it's a tool to help get through that data.
And when you do all this processing, you have your documents OCR, you've pulled out the metadata, you've extracted the text, you've deduped and all the rest of it. How do we take advantage of all that to allow, say, a client comes to us and say, we did all that stuff, and now they say, well, I got to look at this, either it's production that's been produced from the other side in that format, or it's our own documents that we're deciding what needs to be produced or not. Is something privileged going through, those types of things? How do we provide them with the visibility of these documents so that they can easily do, their review of these records?
Well, we work with them to come up with a review strategy to help them decide what they're going to look at. And a lot of times our clients, they want to pick off the more relevant stuff first. So, we can kind of help segregate that out. And going into that, I mean, you're looking at, keyword searches. We can use what we've previously done and create, these terms seem to be more important and are going to ultimately return more important documents than some of the lesser ones. So we can use that to help pull documents for the clients, the attorneys to review first. We can use date ranges. We can use the tools available to us to allow them to kind of segregate these into buckets so that they can review these in a timely fashion and kind of work their way backward from the most relevant to the least.
And this is typically done through an interface we provide online where the lawyers can just log in and see their own records?
Oh, yes. I'm sorry. So yeah, that would be a review platform that we have for the attorneys that allows them to see the documents they can look at just the text version, which is the extracted text or the OCR text. They have, all these platforms now have a native viewer, and it's basically a rendering of how that would have looked if it's an email from Outlook, how it would have looked in Microsoft whenever that email was being viewed, created by whoever did so. And it allows you to see all the metadata as well. So you can see all the date, custodians, title, all that information readily in one system. And it allows you to go between documents fairly quickly because these systems are built that it knows that it's going to have an email that's an MSG file, and then it's going to have an attachment that's a PDF file, and then it's going to have an attachment that's an image file, like a JPEG. So you don't have to open up an MSG and then go out and try, okay, well, now I got to open up Adobe to look at the PDF. They just seamlessly, you can just scroll through. It doesn't matter, what the document is or what type of file it is. It'll allow you to view that in succession.
And in viewing that, you're not messing any of the metadata up, correct?
Correct. You're not altering anything. The way that it existed is the way that it's going to exist. You're not going to alter any of that data by accidentally hitting save on top. Like if you would open up that if you need to open up that document in, say Word, and then you accidentally hit save, now you just
change the save date.
The save date. So yeah, you don't have any worries of altering any metadata at that point.
And once it's in a database like this, we can slice and dice it 1,000 different ways depending on what the use case is. If they're reviewing for production, they can be identifying documents that are privileged, flagging what the reason is that they're privileged for, apply redactions if they need to make it producible, do some issue coding along the way, say, hey, this is a hot doc, or I'm going to want to talk to this person in their deposition about it. Utilizing these same types of tools for a production receive from the other side. So once it's all in there, it's all organized. It's organized in a fashion that, if we're looking at issue coding, for instance, and there's an issue related to one of 4 main things, it's a choice, and you can just check mark box which of these documents deals with. And so later on, when you're dealing with whether it's depositions or motion writing or briefing, whatever it may be on the case, you can go back and retrieve all the documents you flagged as dealing with that issue and see if they add value to your case or not. So I think organizing all this stuff in that database really can become valuable in your organization and the availability of using all these pieces of data that we just described.
Yes, and going back and grabbing it all at one time, like you said. Now you've gone through, you've read, you've reviewed your 10,000 relevant documents for this issue. Maybe 50 of them you want to use. Now, do I go back through my notes and say, I wrote down, a number somewhere and try to piece that all together? If you tagged it appropriately, now you can just go back into the system and say, pull everything that I tagged that had to do with this issue, and there's your document set right there. So it definitely helps in organization and taking care of, getting your relevant data set quickly.
And when we're running things through a platform like this, when it comes time to produce documents, do we have lots of options about how to produce them at that point, or are we limited and say we have to produce it in one way?
No, we can produce it basically. It's been known as the industry standard, but basically any industry standard format we can produce in. We can produce in PDF, flat PDF. Some people still want to produce that way, but we can produce in flat PDF. We can produce in searchable PDF. We can produce in images and text files and load files to put it into a review system. We can produce it natively, and any way that anybody would want it, we can produce it in that way.
You could theoretically print it off if you had to.
Theoretically, yes.
Yeah. I wouldn't recommend it, but you could. And using something like this process, a system like this, how does this help in the creation of a privilege log?
Well, so it allows you to use all your metadata fields, and we can export that out into an Excel spreadsheet fairly easily. And if, like you said, we have issue tags, we have privilege tags set up as well, that it's, this document is privileged, it's attorney-client privilege, it's attorney work product, whatever it may be. If those are tagged appropriately, those will come out into the Excel spreadsheet as well. So we can supply our clients with an Excel spreadsheet of document ID, date the document was created, title, the privilege designation, the privilege reason designation, and then they can go through and fairly quickly turn it into something that they can produce to the other side to identify these documents to allow the opposing side to make their claims if they want to contest the privilege.
And a lot of times we see that the metadata alone that we get out is sufficient to give a description of the document, that they don't have to add any more textual description about it. So for instance, if I said, hey, this is an email from Bill to Pete on June 19th, 2024, and the email subject is, we need to review this claim, and it had this attachment, and the attachment to the title is legal analysis of claim. and we're calling both of these, attorney work product or whatever it might be, or attorney-client communication, that's enough. And all those are fields that we can pull out of the database to create that privilege log that gives the attorney everything they need to say, this is the document I'm withholding, here's why I'm withholding it, and you can see the descriptive content of why I would withhold this record.
Yes.
Okay. And our last topic for today on this episode is search strategies. And we've kind of talked generally around search strategies in terms of using keywords and Boolean searching and things like that. But there are a lot of, and we won't have time to get into all this today, but there's a lot of analytical search tools and different things like that that are available, coming to the forefront, going to be potentially available and easier to use in the future here as AI gets more integrated into eDiscovery and into the legal fields and things like that. Concept search engines that say, hey, if you find a document that you think is important, relevant, critical, whatever it might be, and it's conceptually talking about these issues, the computer can actually go out and say, well, I think these other documents are conceptually similar as well, regardless of what actual terms are used in it. And it does it through all kinds of logic calculations where it says, well, if we have these words within proximity of each other and they're in the same paragraph or they're in separate paragraphs, it's saying it runs that kind of analysis across other records to pull them together. That allows for a sort of more overview carving of your data to do things. My experience, I think yours matches to this, is that most of the time people are still agreeing to search term strategies because they understand it. There isn't a whole lot of questions about, well, how is this set up? What's the logic behind, how a concept engine is running? AI is going to have some of the same issues as it becomes more prevalent. It's like, well, how's the AI making a determination of relevancy? Things like that are why search terms are still a prevalent strategy, I believe, in what we're seeing today. But that's going to be an area I think it's going to change quickly, and that's be something we're going to discuss in our next podcast. But before I let you go, one last thing, because I know this is something that always kind of bothers you, is that I think there's a misconception that eDiscovery is push a button and it's done and over, and there's it's done super quick and there's nothing more to do. It's all computer time. Is that true?
No. So, it has gotten to the point where these processing engines are pushing through a lot more data a lot quicker than the predecessors. It definitely has a lot less error rates than it used to. But this data, it's electronic data. There's multiple steps along the way that data can get corrupted. I mean, everybody, I think, can experience that. Somebody sent you an attachment for a PDF attachment for you to look at. You go ahead and you try to open up that PDF on your system. Oh, it's cannot, unsupported file type or something similar, that you can't open up that file. The person on the other side can send you the same exact file again, and you can open it. So there's every little step along the way, there's a place that this data can get corrupted. So once the data is processed, now you have to go in and manually check all these errors and try to fix them, to a reasonable degree, so that, all the data sets.
And that takes time.
So, whether it's finding password protected files, seeing if there's password, if anybody knows the password, so that we can get those opened up. Whether it's just it's reading the metadata, so the metadata is telling the system that this is an Excel file, but it's really a PDF file. So it's mismatched header types. So little things like that are not really a big deal, but you have to go through. You have to decipher why it's being treated the way it is, and make a reasonable effort to fix and get that data processed so that it's in the data set for your client.
So the moral of the story is, don't wait till the last minute when you have a deadline, and understand that things can take longer. If you have a lot more error files, it's going to take longer to get through all those to fix as many as you can to get to an ultimate production.
Sure. And, I like to tell our clients this as well, is every data set's different. Even when you're producing out of the same case, it's, just a word of advice. We tell our clients we need, 24-hour lead time for production. We may not need that much time. We'll get it to them as quickly as we can, but inevitably there's going to be files that error out, can't image, or something along that line that you have to go back and fix. So, if you have 2,000 documents that you produce on day one, it took you 40 minutes. You might have 2,000 documents on day 5 that takes 4 hours. Every data set's different. Every volume's different. So it just takes time to hash those things out, and it's not automatic.
Well, Bill, that's it for today's podcast. I appreciate you joining us here, and I hope everybody got some good understanding of the overview, the nuts and bolts of eDiscovery. I'd invite them to come back to our next episode where we're going to do a little bit of storytelling, talk about some things that people commonly come to us with, either as questions or requests, or cases that we've dealt with that I think would be relevant. And then discuss where we see the discovery industry kind of moving in the future. So I think it's going to be a very interesting episode. So thank you for joining us for Data Discourse, practical advice and insights about digital forensics and eDiscovery. And we will see you on the next episode.
All right, take care.